One of the most common problems Filipinos have is dividing their inheritance from relatives or loved ones who have passed on. This is usually due to the lack of will or testamentary succession left by the deceased. A will is an act whereby a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of his estate, to take effect after his death. However, creating a will is not a common practice in the Philippines, but any lawyer in the country would recommend that everyone should at least reconsider it. When it comes to preparing a will, what are the steps and requirements needed to write one? Is the assistance or a presence of a lawyer required? What are the advantages of making a will, especially since it is not a common practice of Filipinos? Good evening. You are watching Legal Help Desk on the Solar News channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Rod Nepomuceno. Tonight, we will discuss your legal rights on testate succession, what you need to know about testate succession, as well as what you need to know on how to write a will and the requirements needed to make one.
Our guests for tonight are Attorney Norieva de Vega and Attorney Crisanto Nicolas of the Nicolas and de Vega Law Office.
All right. Good evening, Attorney Carlo.
Hi, Rod.
Attorney Nikki.
Good evening, Rod.
Good evening. Thanks for joining us. Now, this topic is a paradox in a way because a lot of people don't like talking about it. You know, they think it's a morbid thing, but at the same time, we get a lot of questions regarding it. So in a way, it's
and
very
also, I
interesting
think
topic,
to be practical, a lot of people are starting to realize that we should really plan for death. Meaning, paano mo ba i-distribute yung may iwan mong pera o yung mga kagamitan? So, in other words, yung mana, di ba, na pinag-uusapan. It's usually a sensitive topic, but I think a lot of people are starting to be practical about this.
Yeah, and I think it's also important to point out that inheritance, the word inheritance, most people think it relates to the one who's inheriting it. When in fact, inheritance is actually, in a technical sense, belongs to the testator, no? The one who's gonna. So, and it's a totality, hindi lang yung property niya, but it's also pati mga utang, di ba? And the rights and obligations.
So I guess let's go now to basically if you have properties and you're already planning, not necessarily kung matanda ka na, but this is something we can clarify to people. What does it take to plan for distributing your wealth upon death? Tsaka ano yung advantages of doing that?
Yeah.
It's actually very simple to do a will, as we will discuss later on. There's such a thing as holographic will. Hindi mo kailangan ng abogado.
So it's not as complex as
most
people think.
Hindi magastos. You don't even need a lawyer. You don't even need any formalities. It's just very simple.
Okay.
And kasi in our experience, it's very sad. Ang pinakamasakit talaga ng mga kaso, yung magkakapatid nag-aaway-aaway.
Yeah.
And that will happen if you don't do a will and you don't take care of it before you die. Nag-aaway yan. Kasi usually, pag nawala yung patriarch or yung pinakapuno ng pamilya, nawawala yung bond nila, and then may, yung mga hang-ups ng bata pa na paborito to, paborito, itong isa, it crops up. And then, yun ang grabing mag-away sa kaso, magkakapatid.
But Attorney Carlo, maybe you can differentiate kung anong effect. If you don't leave a will, paano ba hatiin yung ari-arian mo, and how different is it kung meron ka naiwan na will?
Well, first, let's highlight the importance of a will nga. Like you said, it's something that's catching up. Imagine, let's put into perspective. You want to buy a car or a house. You draft a contract of sale. Now, if you die, you're leaving all of those properties behind. Not merely a house, not merely a car, but everything that you owned, that you worked for. Yet you will not put something in writing. So that is why people probably are taking into consideration that it might be important to look into succession. Now, should we draw a will or should we just leave it to the law? The difference would be, if there is a will, you can control to a certain extent permitted by law. If there is no will, you let the law control for you.
Siguro for the benefit of our viewers, let's give an example. You have a man who has a wife and 2 kids. Without a will, tapos may nangyari dito sa father na to, paano i-distribute yung ari-arian niya?
Let's say walang will.
Yeah, walang will.
Okay.
So we'll go to intestacy. So una yan, you cut it in half because the half belongs to the wife.
Yes, that's
And then
correct.
the remaining half, that's what will be divided
Of
equally.
all the properties to.
Yes.
Again, without being technical, because assuming they got married under
Yes,
after the
absolute
family code,
yes,
absolute community
absolute
of
community of
property.
property.
So
So
half goes to the wife.
goes to the wife,
Okay.
and then the other half will be divided equally amongst the 2 children and the wife. So, I'm not very good with math, pero siguro tag one-third sila doon sa
Dun
half.
sa value ng other
Yes.
half.
Yes,
Oo.
yes.
So, kunwari, let's say, 2 million pesos, 1 million automatically goes to the wife.
yeah.
The other 1 million, paghahatian pa nung wife and the 2 kids ng equal shares. So,
Yes.
tigo 1/3.
So
Okay.
no, in a way, the wife becomes considered as one child, one
That's
legitimate
correct.
child.
One
Yes,
legitimate
yes.
child.
Okay. So,
Okay.
pag yun ang assuming legitimate, kung
yes.
meron siyang illegitimate child, ito yung laging
Dun nagiging
controversial. Sasabihin
complicated,
nila,
Yes.
anak ka lang sa labas, wala kang karapatan sa mana. Pero, I guess you can clarify.
Merong karapatan ng illegitimate child, they get 1/2 of the share of a legitimate child.
One half.
And with the onset of the family code, before there was a lull with respect to the adopted children. But with the onset of the family code, at least it's explicit that the adopted child will have the same rights as a legitimate child.
So, in this example, assuming walang anak sa labas yung dad na ito, then it's about 300,000 roughly each.
Yes.
The mother and the 2 kids. Pero kung may anak sa labas, then yung anak sa labas pa would have to get around
One half.
One half.
Oo, one half of, so hindi na tig 300,000.
Pero to clarify, yung mistress wala
Pero
Yung mistress
normally
wala.
during the life yun. During the life.
During the life na yung binibigyan.
Nakaka-advance.
A lot of people are asking, no? Let's say if there's a wife and their, let's say, children, legitimate children.
Wife and children.
Do the parents intestate? Again, we have to clarify to our viewers. Pag sinabi natin testate succession, that means dying
will na.
with a will.
May will.
And those, if it's intestate, that means dying without a will. No? So let's say, in this case, wala mo ng will, no? Because we're going to talk about wills later on. Walang will, and then you have a wife and 2 legitimate children.
Okay.
Do the parents and the brothers and sisters inherit?
Doon na papasok yung rules of exclusion.
Okay.
The-
Yan.
According to succession, love goes down first before it ascends.
Okay.
So what does that mean? If there are descendants, then they would be taken priority. Then with the parents present together with the ascendants, the parents would be naturally excluded.
Excluded.
Kasi bababa muna siya.
Bababa.
Bago siya
Okay.
umakyat.
And then, so from there, we already know how to distribute yung theoretically in our example, pagka namatay ng walang will. How can you change that? If you're the dad in this example who passed away, how can you change the distribution if you write a will?
Well,
You have a wife and 2 kids, so
You can give more actually
Yes.
to, let's say, if you have a favorite child. Pwede mong dagdagan. Ang general rule lang is you don't encroach on the legitim na tinatawag. As a compulsory heir, yung anak, hindi mo pwedeng bawasan yung binibigay sa kanya ng batas.
Let's explain
so,
legitim.
ano,
Kasi,
yung legitim, bale, automatic yan na kunwari kaming dalawa ni Rod, ang anak nyo, o kunwari ikaw yung dad, you're the mom, tapos mas favorite mo si Rod, Carlos.
For one reason or another.
How can you increase his share without removing my right? Ano yung automatic ko na right na hindi mo pwedeng galawin?
let's say with 100,000, the value of the estate, of my estate. So half of that would be the conjugal share.
50,000.
So it would be 50,000. Now with that 50,000, let's divide it further into half. Half would be reserved for the legitim, and the half would be reserved for the free portion.
Free portion.
Now,
So
legitim is
25,000.
what the law mandates that you
Yeah.
should give.
That's correct.
So,
the
hindi
bare
mo pwedeng
minimum.
galawin yun. You
Yes,
cannot
yes.
manipulate that.
Yes.
Alright?
So kunwari, if you took aside the 25,000, yun pa yung paghahatian naming tatlo, the wife and the 2 legitimate children.
That's correct.
And then the other extra 25,000, pwede mo ibuhos lahat kay Rod through a will.
That's
Yes.
correct.
Okay, so lalaki nga yung share mo.
So
compared
basically, if you said in your will, all to Rod, all to Rod, effectively, ang mapupunta lang sa akin out of that 100,000 is really just 25, right? You cannot, in
Yes,
other words, it
yes.
can't be the whole 100.
Yes.
Right? Unlike, I
That's
think,
correct.
in other jurisdictions like in the
in
US,
other
you
parts
give
of
to
the
your
world,
dog, I think,
Or to a stranger,
to a
yes.
stranger,
Yes.
or to ano. But in this case, the law, I guess, provides protection.
It's
for,
the implied will.
Implied will.
That's
It's the
why
implied
it's
will.
it's always better to have a will rather than without a will, because we would not want our legislators who was not really part of our family to say
to decide kanino ibibigay.
Yes.
And of course, when you're talking about the free portion, as long as nasatisfy yung required share ni Rod as your legitimate son and me, for instance, as your legitimate daughter, pwede mo ipamigay yung tinatawag natin free portion to your friends,
That's
to
correct.
anyone,
To anyone.
even to your,
To charity,
to your
to the-
kasambahay na nag-alaga sa'yo, for instance, or to charity.
Or
So, to
maybe as
anyone
part of the
talaga.
DAP.
Oy, iba pa yan.
Diba yun?
Now, who can make a will? Because a lot of people are thinking only if you're 50 plus or 60 plus or 70 plus, they think that making a will is for old people. But who can make a will? And at what state of mind, etc.
Basic requirement lang, anyone not prohibited by law can make a will. So it means anyone at least 18 years of age and older.
So at 18, you can make a
So, kailangan
Yes.
of age ka na, hindi pwedeng bata pa, hindi
oo.
pwedeng...
And of sound mind dapat.
Okay.
Oo.
Yun yung sound mind. Yun yung
Yes,
medyo
yes.
question mark. Marami nagtatanong. How do you determine that, di ba? Is it the time when you were making the will? Or?
Yes, at that you see, I look at wills as a basic contract. If you buy something, you must know what you're buying. So, like in a will, if you want to divide your property, you must know how to divide it. Who will you be giving that to? So that is actually a basic requisite of soundness of mind.
So summary, basta you're 18, sound mind.
Sound
you can,
mind,
you can
yes.
make a will. Okay.
Oo.
All right.
So, we still have a lot to discuss. I want to go into the specifics kung paano talaga sinusulat, kailangan pa bang panotarize yan. But for now, we'll have to take a short break. Legal Help Desk will return after these messages. You're still watching Legal Help Desk on the Solar News Channel with our guests, Attorney Norieva De Vega and Attorney Crisanto Nicolas of the Nicolas and De Vega Law Office.
Okay, Attorney Carlo, Attorney Nikki. So, let's discuss naman yung formalities, di ba? Formalities. So, you mentioned there are two types of wills earlier. You said the holographic will, which is written. Let's go later na lang yun.
Okay.
I think that's easier. But let's go to what you mentioned, the notarial will.
Notarial will,
Okay.
yes.
There are several things that the law provides, the technicalities and formalities, formal requirements. What are those formal requirements of having a notarial will?
Well, first, it must be subscribed by the testator.
When you say subscribe, what do you mean by that?
What do you mean by that?
Subscribe, but he must sign it.
Okay.
To put it simply, sign it. And
Kailangan bang typewritten?
yes, it must be for a notarial will. It's
Must be
written.
typewritten. Okay.
Yes, and it must be signed on each and every page except the last on the left
On the
hand
left.
margin. Okay.
Hold on, I'll pause it at this point. When you specify left, if it was signed the right, it can potentially not be allowed?
Yes, that you run that risk. Although there is a civil code provision which states substantial compliance.
Okay.
There was this instance, one of the witnesses forgot to sign one
One of the
page, then the
pages.
lift, and you
Yeah.
usually sign many pages, and it was allowed by the Supreme
Okay, the reason why I
Court.
asked that, because we really have to be careful
Yes.
here. Kasi when the court's already studying and evaluating the
Yeah.
will, it's very important that you list down these formalities,
Yeah.
which are
Well,
very
as-
important.
And we have to clarify to the people kasi if you leave a will, in order for it to be followed, meaning kung masunod yung linagay nyo doon, you have to comply with all of these requirements that are being enumerated by Attorney Nikki.
So subscribe and then signed on the left.
And
what else
dapat
pa ba?
written.
And
It has to be in
written.
writing.
Typewritten,
Oo,
okay.
sign on the left side, left margin.
Three
And then-
witnesses.
Three
very
witnesses,
important.
okay.
Signing-
Credible witnesses.
credible witnesses who are not disqualified under the law.
When not disqualified, give an example. If you're
Bilo-
inheriting, kung nakalagay yung pangalan mo as one of the tagapagmana dun sa will,
But my witness is actually an Australian friend who does not live in the Philippines.
Okay, disqualified
The
yun.
law requires that he must be a Philippine resident.
kailangan resident ng Philippines. Hindi kailangan Filipino citizen, pero kailangan resident ng
Yes,
Pilipinas.
domiciled here in the Philippines.
Okay.
Or convicted of perjury.
Yeah, he cannot be a
cannot be.
witness.
So
Yes.
dapat walang conviction.
Ang mistress ba pwedeng witness?
Ah,
Wala pa jurisprudence
Wala
yan.
pang jurisprudence, wala kang
As
maamin.
long as hindi halata, hindi alam.
Kailangan ba, that witness should be able to read and write?
Yes.
yes, because
Okay.
that's a requirement. They
That's
have
a
to
requirement.
attest that the testator understood
Okay.
what the will is.
Requirements also for a witness, it must be over 18 years of age.
Okay, over 18.
Must not be blind, deaf, and dumb. Must be able to read and write. So yun ang mga requirements for the witness.
Kailangan ba may lawyer?
By dumb as in pipe, ah. Baka
pipe.
sabihin mo, I know, pag low IQ, hindi pwede.
It's not related to
And then, of
Good
course,
point.
that disqualification na if you're assuming daughter ko or any na any person na tagapagmana rin, bawal mag-witness.
Mag-witness.
And then,
Okay.
so
And what
3
else?
witnesses,
Yeah,
what
three
else?
witnesses?
And the 3 witnesses must subscribe and attest to the signing of the will in front of the testator and of each other.
Each other, yes.
Okay.
Okay, so hindi pwedeng parang separate room sila nagpipirmahan, they don't see each other signing.
Okay. The
So,
witnesses
kailangan-
each of the witnesses should be seeing the other witnesses signing.
yes, yes.
In
And
the
they
same
should
room.
see
Same
the
room.
person making the will also
correct.
signing the will.
That's
in front
yes,
of them.
in front
So
of
madugo,
them.
no? So do you need a lawyer there? Do you need a lawyer at that time in a notarial will?
Not yet.
Not yet.
Not yet. But you see, you can further expand this. The law does not give answers to the present situation, like can you do it via Skype? Because you can see each other, right? I mean, these are things that maybe later on
Yeah.
our legislators
But I
can
suppose
address.
to be safe, we have
Yes.
to tell
Oo.
our viewers, just follow yung normal requirements na
Yes.
hindi magbibigay ng gray area, meaning be physically in front of each other and then you have to see the testator sign.
Now language. May ano bang requirement ba sa language?
It must be in a language or dialect known to the testator.
So
Alright.
pwedeng Bicolano,
Yes.
Ilocano.
Okay.
Dik-
Wait, hold on. Sorry, we have sorry to interrupt. We have a caller on the line, and our caller's name is Janet. Janet, good evening. Are you there?
Hello, good evening. Si Janet po to from Cebu.
Okay, hi Janet. What's your question, ma'am?
It's like this. I'm married for 20 years now. And then yung naasawa ko is divorced siya. May dalawa siyang anak.
Okay.
And then meron kaming prenup. And then along the way, may negosyo kami. Magtanong lang ako kung may claim pa ba yung dalawang anak niya sa first wife niya sa negosyo namin?
Okay. So walang will. Meron silang prenuptial agreement. But this,
See, Janet and the current husband have a
yes.
prenup.
Di ba, Janet, may prenup agreement kayo?
Oo, meron.
And does it cover the business na pinag-uusapan ninyo? Na,
Wala. Hindi na-mention yan.
Hindi na
okay.
mention.
But in the prenup, ano yung pinag-uusapan nyo na kasama sa ari-arian ng husband mo?
Kasi at that time, wala pa kami negosyo. Yung mga sinabi niya sa prenup, yung may certain amount na para sa akin every year, ganon, na we stayed married together. And then, ang tanong ko lang kasi may dalawa siyang anak na sa labas, kung may claim ba yung anak niya sa negosyo namin in case may mangyari sa asawa ko.
May anak siya sa labas or
From the first wife.
From the first wife.
Yeah.
The question is actually difficult from the standpoint of Philippine law because we do not have divorce here.
Yeah.
So we have to look at
I think you were legitimately annulled, no?
another divorce. That is a
Annulled ba kayo?
Kasi parang yung husband ko. Pero,
Okay, that's recognized here. Oh.
A foreigner
pero
siya?
after the divorce, married kami legally dito sa country niya.
Okay. Since we're assuming that his country, his original country, is he American or anong country siya? If his country allows divorce, then pwede. You can get
Germany.
Germany. Okay,
Germany,
so we assume that that's allowed. Okay, but he does have legitimate children from the previous marriage. Is that what you're saying,
Oo,
Janet?
meron.
So ang tanong ni Janet, may claim ba yung 2 legitimate children?
Dun sa
from the-
business na nila ngayon.
Sa business nila ngayon.
Oo. Kung may mangyari dun sa husband niya.
May mangyari sa husband niya.
So
hindi
we're
sa
talking
kanya.
about,
In the
yung
future,
potential na succession in a sense kung walang walang will.
by analogy, most probably yes, because even after a decree of annulment, for example, the ties between the legitimate children and one of the parents still exists. It's only the tie between the
But maybe to clarify to
spouses.
Janet, yung mahahabol lang ng mga anak ng husband mo from the previous marriage will be from his share.
That's correct.
Meaning dun sa share niya, dun sa negosyo ninyo. With respect to your share, they cannot touch that. So,
Doon yung negosyo is under my name.
Even if the negosyo is under your name. Yes.
Yes, there's a
Kasi-
presumption
yes.
of
Of
conjugality.
conjugality, yeah.
kaya tinatanong namin, Janet, kanina kung anong cover ng prenup. Kasi kung sa prenup ninyo, ine-exclude yung mga properties that are in your name, then baka sakaling you can argue that walang share yung husband mo dun sa business, therefore, yung mga anak niya rin, walang share dito sa business mo if something happens to him.
I think you should also ask Janet if
Namin, nag-exist lang yun, yung mga 5 years later na sa marriage namin.
Yung business only happened 5 years into the marriage.
5 years into the marriage.
Okay.
One thing siguro that you should ask Janet is what are the laws in that other country? Because perhaps in those laws there's a specific provision applicable to the children of the divorce, the first wife, that may perhaps say pwede or hindi. That's why I said it's difficult because you're dealing with Philippine law and also of American law.
Yeah.
Or
that's
German,
true.
German law, I'm sorry.
Although
German
sa
law.
atin, just to give you broad advice, normally meron tayong tinatawag na rules pagka may conflict ng dalawang laws sa bansa ng Germany and the Philippines. So, when property is located here, kung yung business nyo ay located dito, lalo na kung may mga assets yan, mga kotse, building, ang mag-a-apply would be Philippine law. And sa batas natin, if you did not exclude this in your prenuptial agreement, meaning hindi naka-exclude doon na kung ano magiging negosyo nyo ay pag-aari mo lang or na sa'yo lang pagka nasa pangalan mo, then ang assumption dyan would be hati kayo dun sa negosyo. So, to the extent na yung half ng negosyo would be in the name of, pag-aari ng husband mo, then if something happens to him, the children, the legitimate children from the first marriage would have a claim to their share. Pero dun sa share pa ng husband mo, again, may share ka rin dun as the legitimate wife.
All right. We hope to help you out. Okay. Hope we help you out, Janet.
Pero ask him to make a will na, Janet.
Ask him to make a will.
Para
Tama.
yung to the extent na yung portion doon, as long as masatisfy niya yung share ng mga anak, then the rest, ibigay niya na sa'yo, di ba?
All right.
Okay.
Thank you very much, Janet.
Okay.
Thank you.
Okay, thank you. Thank
Okay,
you.
we have a lot of questions.
Yeah, we have
Lisa.
another question from Twitter.
Yeah.
Lisa tweeted, "My wife and I have acquired some lands and plan on making a will stating we leave everything to our children. What are the steps and requirements that we need to make a will?"
Okay.
To you.
Oh, yeah, we're going through
Yeah,
that.
kanina, di ba?
Yeah.
So,
Well, if
maybe
you were listening
Attorney
earlier,
Vicky can continue, no?
yeah, if you were listening earlier, Lisa, we made a rundown of all the requirements of a notarial will. Maybe that might be an appropriate time to bring up a holographic will, a written will.
So kanina, let's finish first yung written, notarized, tatlong witnesses who have to sign on the left-hand side. And very important that we haven't discussed it, kailangan ng notary public.
Yes, acknowledge before a notary public.
Yeah. Now, I read also that it's not sufficient to have a jurat, but it has to be an attestation
Attestation
clause.
clause.
Can you explain a little bit what an attestation clause is compared to a jurat?
It's in the clause indicated under the law, under the civil code. It says that the witnesses signed in the presence of each other and of the testator, and that they appear before the notary public. So they must comply with what the civil code actually provides. If they
And the number of pages.
yes, and the number of pages.
Yeah.
If they
So hindi
miss-
lang sufficient yung usual
Yes.
Yes, oo.
affidavit na jurat.
Yes,
Hindi sufficient
Hindi
yun.
That's
sufficient.
Siguro let's go, obviously yung notarial will, ang dami-daming requirements. So to be safe,
Yeah.
maybe you need a lawyer or someone who knows the law to be there for you and ask, may checklist, okay, na-comply na lahat. But maybe yung mas simpleng type of will na hindi kailangan lahat ng requirements na to. That's the holographic
holographic
will.
will.
That
Okay.
maybe you can give the requirements for that.
The only requirements here, it must be entirely dated, signed, and written by the testator.
Ayun, mas
Yun lang.
mas simple yun. Dated, signed,
Signed,
and written.
Written, handwritten.
Fully
ah.
written.
Oo,
So it can't be
handwritten.
partially typed and then
No,
additional. So it has to be fully written. And who will then attest to the fact that it was handwritten and really made by the testator?
If you file it in court already, then the court will require 3 witnesses who are familiar with the handwriting of the
Pag
testator.
contested. Pag hindi contested,
yes.
isa lang.
Isa lang. Alright.
So if you do a holographic will, be prepared that you will have 3 people who will testify that this is your handwriting.
Now, pwede ba yan, let's say, on a tissue paper or kailangan papel? What kind of form? If I wrote it in a wall, for example. If I wrote, I know we're going absurd here, but let's say I wrote it in a book. I wrote in a book. But sometimes, they don't have a piece of paper. You're dying, you write. And it happened to my uncle.
Oh,
he was
Wala
dying.
man na
and-
nag-abot ng papel.
Wala. So they did the pro forma and the thumb mark lang siya. No? But so it can happen that you may not have a piece of paper at the time and then you're dying. Let's say, does it require it to be in what particular piece of paper or?
Entirely possible. That is entirely possible. So long as the testator was sound of disposing mind at the time, and knew that he was actually writing a will and written, dated, and signed that
That's
tissue paper.
sufficient.
That would be
Yes, that's sufficient.
Okay, so
Okay.
that's the more simple one.
All right.
Okay, we still have more to discuss with our guests. Legal Help Desk will be back, so stay tuned.
Teacher.
You're still watching Legal Help Desk on the Solar News Channel with our guests, Attorney Norieva de Vega and Attorney Crisanto Nicolas of the Nicolas and de Vega Law Office.
Okay, so again, Attorney Carlo, Attorney Nikki. So we just finished discussing yung holographic will,
Which is the more simple
which is the simpler one.
Yeah.
So for those people who are a bit confused, with all the requirements of a notarial will, it's actually maybe it's advisable. If you find that too complex, you can just write a will. And could it be as simple as that, as basically saying, all to my wife and to my children, and then dated and signed?
Form of a love letter? Yes.
Form of a love will. Okay.
Entirely written, dated, and signed by the
And
testator.
it doesn't matter if it contains extraneous things like your philosophy in life and
pagka
all that.
kunwari, sinulatan ka ng husband mo and it says, to my dear wife, I leave everything to you and to our children. Tapos sinay niya and dated. So I can present that to court and say, ito yung will niya.
Well, there's the difficult part, the intent. Because you must have disposing intent. I mean, you must intend that written instrument to be the will. Because it could be just some scribbling or, random things that we just write, but we did not really intend that to be our will.
Okay.
So,
So
yes.
if it's very clear na it's in the form of a love letter, pero nakalagay, upon my death, I want to
Yes.
make sure that I leave everything to you and our children, or I leave everything to you and our children, then it's possible that you can
Yes.
present that to court and say, this is his will.
That's possible, yes.
Now, if there's any portion of the disposition, and then we were talking about this off cam, di ba? Like, for example, I don't like one of my kids, and I omit him from my will. Kunyari, I was specific to child A, child B, child C, and then I had the child D that I totally omitted.
Or that you wrote to, kunwari, child D, I will leave nothing.
I will leave nothing. Ano yung effect nun? Ano yung effect of that? Which I understand it's called preterition or there's a technical term for it. But does that have the effect of disinheriting your child?
No, it doesn't have that effect. Actually, it produces devastating results. No? It will annul the institution of heirs.
Meaning the whole will becomes null and void. The court will not.
Leaving legacies.
Legacies and
the
devices.
But if there are no legacies and devices, then you're right.
Oo,
The
siguro
entire will.
clarify first to
Yeah,
our non-lawyer viewers out there, what do you mean by legacies and devices?
Well, if there's a will and you have children and you have a free portion that you give to friends, for example, or to a particular institution, then these are legacies and devices.
Devices more on the real property, personal property, yung
So
legacies.
kunwari, I have several properties, I have a house and lot, I have a condominium, cars, and then I decided, Rod, as my very loyal
friend.
co-host,
Ayun.
I give one of my cars to
All
you.
right.
So that's a
Ayun.
device, okay?
Which car?
It depends which car. So, assuming, let's say, I leave
I
a Mercedes
accept.
Benz for Rod. So, yun, that will be respected.
Yes.
Yes.
And then the rest of my properties, yun
The
yung,
rest of the disposition would be
yun yung void
annulled.
na.
So what happens there is that will intestate succession come into play?
To
Yung
that extent, yes.
The rules
Yes.
of intestate succession, meaning the rules na pag walang will.
Legitim, oo, yung compulsory
So,
heirs.
siguro just to clarify to the viewers, kunwari in that example, I left a gift to my friend Rod, na yung kotse nga, but then the rest of my properties, I divided to my 3 kids when in fact I have 4. Tapos tinanggal ko yung isa dahil nagalit ako dun sa 4th child. Then because I removed this child and that removal is invalid, hindi ka pwedeng basta-basta mag-disinherit, then what happens is as if walang will, they will just divide it according to yung rule natin
Yes.
kanina. Equal na hatian sa kanila.
But this is how technical succession is. If you add just one minor detail, for example, during the lifetime of the testator, binigyan siya ng kotse. That could be a donation. So instead of annulling everything, it's just a mere completion of legitim. So everything that was stated in the will be respected. dadagdagan mo lang kung ano yung kulang.
Actually, that's interesting that you brought that up, Attorney
It happens,
Carlo. Kasi
yes.
that's actually a running joke among my sisters na pagka mahal ang taste mo masyado, lagi ka nagpapabiling mahal na alahas sa parents mo, binilihan ka ng mahal na kotse, but your other siblings hindi naman, they can later on question that and say, yan na yung nagpa-advance ka na
Yes,
sa mana
that's
mo.
correct.
Sa mana.
And ima-minus nila dun sa kwentahan. So,
Ano may donation inter vivos, they call it.
Yes,
Okay.
yes.
So, is that taken into account when computing for the inheritance or
It is.
the estate?
It
Yes.
is. Because sometimes a parent can be too picky and bibigay lahat dun sa favorite, leaving almost
May
nothing.
alam akong ganun. May mga alam akong ganun na may favorite sila. Pero,
but since we're talking about leaving out some compulsory heirs like yung anak mo or yung wife mo na that might affect your will, ano yung talagang grounds for disinheriting? Wherein, kasi people will be asking, so never na. Like, what if ang laki-laki ng kasalanan sa akin ng isang anak ko? Do you mean to tell me I still have to give him property when I die? So, what's the rule here? When can you really disinherit?
Well, the grounds for disinheritance are very specific. So if it's not there, you cannot use that. But let's look at the more basic examples.
Some of the examples, yeah.
Commission of a crime. Kasi you're talking about 3 heirs here, for the parent, the spouse, and the children, right? So commission of a crime, if the testator is a parent, then commission of a crime by a child against a parent would be a ground to disinherit.
Any crime?
Yes, any crime. Any crime. Commission of a crime. Example naman, spouse. If you commit a ground for legal separation, gives ground for legal separation, let's say violence or ng babae, that would be a ground for disinheritance also. But the point there is a restrictive enumeration that if it's not there, for example, nagsigawan lang kayo, that might not be sufficient for disinheriting a person.
Okay.
Even
Attempted murder.
Ayun, attempt
Yes.
on the life.
Grounds.
attempt on the life of
And I
parent,
believe
spouse,
I think if
ascendant.
you impute a crime, di ba, involving a particular level of punishment,
If
di ba?
it's proven to
6
be ground.
years.
6 years, di ba? If
Yun
it's
yung
a- if you
unworthiness
impute a crime.
naman. Meron ding sinasabi, incapable of succeeding by virtue of unworthiness. Kasama doon. Or if let's say you prostitute your child. So as a parent, you're unworthy to inherit from your child. And plus,
So, may mga ganon,
may ganyan. Oh.
you can disinherit. But of course, the burden of proof will be on those claiming that there was
Yes,
disinheritance.
But
di ba?
that's a very interesting
Yeah.
point, yung sinabi ni Attorney Carlo na grounds for legal separation. So, pag nambababae yung asawa
That's
mo,
correct. Pwede.
you can disinherit
Enough
them.
na yon. You don't have to prove. You just have to have given ground.
Okay,
Okay,
so very
very
helpful
important.
tip to
Yeah.
the
Yeah,
wives
tip
out
yun.
there na
Okay, kung kayong medyo mayaman, kung medyo may kaya, you can. Kung
Huwag
mga
magpahuli.
husband nyo is
sabi nga ni Nikki, wag daw magpahuli.
Now, meron mga people who are disqualified from inheriting even by will. May mga ganun ba? May mga there's certain types of people who I cannot give to or disqualified.
One example, a priest who has administered the last rites before the testator died.
okay. Alright.
So hindi siya pwede and his relatives within the 4th degree.
So, up to the pinsan nung priest.
Yes. So mahirap maging...
Disqualified yun.
Oo.
Disqualified from
And also, if you are one of the witnesses to the will,
Okay.
you'll be disqualified. Except, of course, ilalabas natin dito yung legitima. If they have legitims, they will still get that. But
Okay.
outside of the legitims, they won't get
And in
anything.
any circumstance, mistress cannot even get anything, even by will.
Even by
Of
will.
course, legitimate, we know, wala. By will, hindi rin pwede.
It's a policy of the law that you cannot give donations such as that to illegal unions.
Alright.
Okay, so
Yan,
for
malinaw yan.
men out there, yung mga...
And women. And
yung
women
mga
out there. who
Okay,
are-
women
Oo
out
nga,
there,
men,
if you have third-party relationships, then you cannot leave anything to them in
Okay.
your will.
All right, we still have some questions from our viewers. A hot topic. Jacob sent us this question. My mom shares a property with her brothers and sisters. They're planning to sell it. If she dies before it's sold, will her kids inherit her share? Or does she have to state that this in her will? Do the kids need to have a special power of attorney? We are U.S. citizens living in the state. So, did you get the situation? So
They're
the
still
mom,
trying to sell the property.
the mom is sharing with her brothers and sisters. They're trying to sell the property, but in case their mom dies, will they automatically take on her share? So ano yung ano?
Yan yung tinatawag na right of representation.
Yes.
Okay.
The children, by virtue of the right of representation, they can inherit dun sa ano ng mother nila, sa share.
And
Oh.
from a practical perspective naman, since they are US citizens, they will encounter difficulty, although they are entitled to inherit. They will encounter administrative difficulty getting the title to their names. So
Because they're
my
US
suggestion is you
Mag-dual sila.
have dual citizenship
Yes,
first before you attempt to do that.
That's a good.
Just to make
that's
it,
a good qualifier. Oo. Yeah.
but you can even
No,
if you're US citizen.
just a point here. No, most people think that the title of let's say inherited property only passes upon a will or the probate or what have you. When does the title or the share actually transfer? At what point does it transfer to the children or the heirs?
It's transmissible upon the point of death.
Okay.
Yan. The law is
So, as
clear
soon as
that,
mamatay,
As soon as mamatay. Okay.
automatically
So it's
entitled to
automatically
their shares.
theirs.
Yes.
Yeah.
Alright.
Although,
But
of
it's an
course,
undivided
yung caveat
Yes.
dito, you have to pay the estate
Yes,
taxes,
ayun.
which is a topic for another
And
episode.
we note also, sabi ng batas natin, property, rights, and obligations which are
Obligations.
transmissible. So while for example, parents have property, but don't forget the rights and obligations.
So kung may utang, mamamana
Babawasan
rin.
yun.
Oo. Mamamana in a sense na kailangan bawasin muna
Yes.
sa properties.
So kunyari, ang utang is 100, ang property ng parents mo 80,000, wala ka nang syempre babayaran kasi to the extent lang of the inheritance. But if there is something remaining, we still have taxes.
Oo. Yeah.
So, mababawasan pa rin.
So in
yun.
other words, you cannot if over ang debt sa property, the heirs
Wala
are
ka
not
makuha.
Yes.
are
So,
not gonna
another
be
important
responsible
point
for
to
that.
viewers out there, ang property na mamana, pero ang utang hindi. So, ibabawas yun dun sa property, pero kung kulang pa yung property pang sagot sa utang ng, for instance, your dad or whoever who passed away, hindi pwedeng singilin sa inyo
Sa'yo.
bilang tagapagmana. Okay, we have another question from Errol. My parents have been married for years, but my father has been living with his mistress for almost a decade. My mother's net worth is bigger compared to my father. Our properties, savings, and cars are named under my mom. In the case that my mother passes before him, what will happen to our house and my mother's assets? Is there a way to make sure that only my mother's children and her siblings get the inheritance by will? Or is it required by law that my father gets half? Ito yung sinabi mo kanina, pwede ma-disqualify yung father na mababae, but how can they ensure that this happens?
Okay.
In this case,
Okay.
the assumption is there's no annulment yet. Diba?
So they're still
just
legally
separated.
married. But, yeah.
They're still legally married. So
You write a will. Preferably siguro a holographic will na lang kasi mas madali. But you make sure that you state there why you're not giving whatever inheritance that your spouse will get. You must specify that he gave ground for annulment, nangaliwa siya. Write it
and
there.
has been living with the mistress for a decade
so
now.
he can be disinherited. He can be
Because
disinherited.
the law
Practical advice, mag-file muna siyang legal separation para wala na ring wala nang kailangan
Walang
proof
question.
na question na talaga ba ng babae. It's already a matter of a public record.
Yeah, that's a very good advice, Errol. Tell the wife, bale, the mother who has most of the assets, to just file for legal separation now. Anyway, having a mistress is a ground to file for legal separation. But of course, to be sure, also make a will that states na mababae, kaya
Yes.
dinidisinherit.
And the problem with legal separation then is at the middle of the proceedings, if somebody dies, either parties, it gets dismissed.
Yeah.
Regardless kung may ebidensya ka na, parule na yung court, pa-decide na siya. If there's no decision and somebody dies, it's as if nothing happened. So, the will is...
To be
Ngayon
sure,
na,
make
gawin
the
mo
will
na
na.
ngayon.
Make
Pag
it
mo
na
ngayon. Diba? Basta handwritten, may date at signed. Okay.
Now, how often can you edit a will? I mean, I might do the will, for example, medyo I'm healthy pa, and well, and of course, maybe my properties will grow, or maybe I'll dispose some of my properties. Ano yung rules though when it comes to editing it and
You can edit a will anytime.
Anytime.
By virtue of a codicil, pwedeng ganon. Or kung halimbawa holographic will, if you erase, kailangan na ika-countersign mo. And then you can revoke a will anytime. You can tear it up, you can burn it, as long as that's your intention. You can even ask someone else to tear it and burn it for you. Basta it's based upon your express instructions.
So, it's always the act of the testator, what he wants to do. If he wants a new will, tearing it up is a positive act. That makes it invalid.
Quickly lang before we end, I know we're gonna end na, no? Pero just because a lot of viewers are asking me also, do all wills have to go through probate? And what is probate? Because
Okay.
people hear that term all the time. What is probate?
Yes, all wills have to undergo probate. So probate means it's a proceeding in court whereby you prove the due authenticity and the execution of the will. So una, titingnan formal requirements if you complied with that. And then second, titingnan yung sound mind, yung testator. And then once the will has been probated, ibig sabihin okay na siya, good to go, settlement na yon. So hindi ka agad hahatiin. The will still has to be reviewed by the court.
First kung whether-
Oh,
okay.
take note, if there's a will, it's the duty of the administrator or any person who has knowledge of the will to give it to the court within 2 months. Otherwise, he stands to be liable for 2,000 pesos. Sige.
Okay.
Bigat?
Dati okay, mabigat yun dati. Pero ngayon,
hindi na. Outdated na yung law. Okay, sayang no, ang dami pa sana.
Dami.
Pwede pag-usapan, but kulang na yung time. So for now, we'd like to thank our guests, Attorney Norieva de Vega and Attorney Crisanto Nicolas of the Nicolas and de Vega Law Office for being with us tonight. Thank you again.
Thank you.
Our pleasure.
Our pleasure.
Legal Help Desk will return after these reminders. Welcome back to Legal Help Desk on the Solar News Channel. And tonight we had a very interesting topic.
I love that topic. That was my favorite subject in law school.
It's really usually a point of contention. Kaya regardless of how morbid it might sound na pag-usapan yung mana at paano i-distribute yung ari-arian mo when you die, it's really a practical thing to do.
Yeah, and it's also, apart from, this is just one aspect of estate planning, by the way. No? Kasi this is just disposition. You also have yung property preservation, di ba? And also yung to determine what you'll have to pay.
Also, I
know?
guess
You know?
a helpful tip here is that you actually do your family a favor, yung mga iiwanan ninyo when you pass away, if you write a will, because hindi na sila mag-aaway-away among themselves kung paano hatiin, because they just follow what's written. And based on our discussion tonight, there are 2 types of will. One is what you call the notarial will. This is more complicated, but once you prove it in court, it's easier to implement kasi it can be very detailed in a sense. Kasi you comply with all the requirements. One, it has to be written, and it has to be in the language that is known to the person who is distributing the properties. Meaning, kung mas komportable na in Tagalog, then Tagalog is fine. But it has to be written. It has to be signed by the person, the testator. Testator yung mamamatay na magpapamigay ng properties. You have to have 3 witnesses. And kailangan of legal age sila. And also, it has to be signed by your witnesses on the left margin on each and every page. And you also have to have a notary public there. And yan pa lang yung mga ibang requirements, but actually as to form, marami pa yan. Kailangan numbered na actually by letters.
By letters.
So,
So
again,
pages,
it helps to have a lawyer there or someone who knows the law. So it's not a requirement na kailangan may lawyer present, but then it helps kasi ang dami-daming requirements.
Yeah, a tip, if you want a notarial, that's why they call it a notarial will, di ba? It really does help. Just don't get any notary public that you see, no? But you get a real lawyer talagang, who's really into succession. And he will provide you with all the details. Yung attestation clause has to be correct. Because the thing is, once, if you miss out any of the technical rules, no, and formalities, it can be totally disregarded by the court. And we don't want that to happen. No? So you know, notarial will. The other one, of course, is the holographic will. And this is more basic and more simple. All it requires really is that it's written. It's
entirely
dated.
by the hand.
Yeah, written entirely.
Hindi pwedeng
okay?
handwriting and then
Correct.
type. Kailangan talagang handwritten.
Yeah, written, dated, and signed. That's all that is required. And of course, that has to be very specific. It doesn't have to be specific. You can say all to my wife and my 2 children. It can just say that, no? But there are certain rules on legitim as to what you can give and what the law sets aside. No? There is such a thing as a legitim, and that's what the law sets aside. We can't summarize all of that in this recap, but basically there are specific provisions under the law, under the civil code, where it outlines what each compulsory heir gets. And after that is set aside, that's the free portion. Yun lang ang you can dispose via will. Okay.
And rule of thumb, kahit gaano pa kayo kagalit sa anak nyo or kung sino family member nyo, kahit sa asawa ninyo, you cannot just suddenly take them out of your will. There are specific grounds for this inheritance. But good news to those with unfaithful wives or husbands, you can disinherit them for unfaithfulness, for instance, and any ground basically for legal separation like physical abuse. So, yun yung mga broad tips natin for this evening.
Correct. And always remember, inheritance covers not just the property, but also the rights and the obligations. And the specific rule there is that basically you inherit the property and of course the utang also. So, ano man yung balance doon, yun lang makukuha nyo as the heirs. But if the utang is more than the properties, you as the heirs will not have to pay for that utang. Minsan kasi may mga utang na loob or parang, di ba? Mga utang ng mga parents ko. So wala. Yung mga utang ng parents nyo is not your utang. All right. Okay. Now we have some questions from our viewers. I think this is for
the past
topics,
week.
The past week, no? Julio is asking, I have an 8-year-old illegitimate son who I've been supporting financially and emotionally. His mother recently got married and wants to adopt my son and change his last name to her new husband. I did not allow this, especially since it will mean that she will not give me visitation rights for him. I'm ready to take this to court if I have to. Do I have a chance of winning this? My son has told me numerous times he favors me more than his mother.
Okay. Good news and bad news, Julio. The mother does not actually have to adopt the son. I'm assuming from your question that the son here is the biological son of your either ex-wife or ex-girlfriend, and you're the biological father, and this is your illegitimate child. But since siya yung biological mother, unless below 18 siya nung pinanganak tong anak nyo, then she does not have to adopt him. But in order for the son to be adopted by her husband, her new husband, you have to give your consent as the biological father. So, hindi basta-basta ma-adopt yan without your consent. And again, another thing about adoption is, lalo na if he's already of age, is that they also take into consideration the sentiments of the child. So, if he does not want to be adopted, lalo na pagka above 18 na, he would have to also give his consent to the adoption.
Did he mention the age of the child?
Hindi.
No,
That's
okay.
why I was saying, kung above 18 na, the child will also have to consent, and that would play a role, if a factor there, if he said na he prefers you over the mother. Okay. We also have received some comments from our viewers on our program. Renan posted on our Facebook page, as a high school teacher, I always recommend your show to my students, since at a very early age, they must be well aware of our laws. Thank you so much. That's a very nice comment.
Thank you very much, ma'am. And more power to you, of course, you're a teacher, and you are a hero. Marian shared his sentiment by saying, ang galing ng program nyo, sir at ma'am. Mabuhay po kayo. Mabuhay ka rin.
Oh, it really warms my heart.
Yes.
Thank you for those comments.
All right. All right, that's all the time that we have for tonight. We wish we had more, but that's it. We'd like to thank all of our viewers who sent us their legal questions via social media. And of course, if you have any questions or comments on tonight's episode, you may send these to our Facebook and Twitter pages. I'm Attorney Nepomuceno.
And I'm Attorney Karen Jimeno. If you have missed any of our previous episodes, you may watch these at your convenience anytime, anywhere, by downloading the Solar News Channel app from Google Play and the Apple App Store. Join us again next Monday as we discuss your legal rights on intestate succession. Good night.
Now, if you die, you're leaving all of those properties behind. Not merely a house, not merely a car, but everything that you owned, that you worked for. Yet you will not put something in writing. So that is why people probably are taking into consideration that it might be important to look into succession. Now, should we draw a will or should we just leave it to the law? The difference would be, if there is a will, you can control to a certain extent permitted by law. If there is no will, you let the law control for you.
Siguro for the benefit of our viewers, let's give an example. You have a man who has a wife and 2 kids. Without a will, tapos may nangyari dito sa father na to, paano i-distribute yung ari-arian niya?
Let's say walang will.
Yeah,
Walang
walang will.
Okay.
So we'll go to intestacy. So una yan, you cut it in half because the half belongs to the wife.
Yes, that's
And then
correct.
the remaining half, that's what will be divided
Of
equally.
all the properties to.
Yes.
Again, without being technical, because assuming they got married under questions regarding it. So
Yeah.
in a way,
And
it's very
also, I
interesting
think to
topic,
be practical, a lot of people are starting to realize that we should really plan for death. Meaning, paano mo ba i-distribute yung may iwan mong pera o yung mga kagamitan? So, in other words, yung mana, di ba,
Yung mana,
na
yeah.
pinag-uusapan. It's usually a sensitive topic, but I think a lot of people are starting to be practical about this.
Yeah, and I think it's also important to point out that inheritance, the word inheritance, most people think it relates to the one who's inheriting it. When in fact, inheritance is actually, in a technical sense, belongs to the testator, no? The one
Yes.
who's gonna. So, and it's a totality, hindi lang yung property niya, but it's also pati mga utang,
Yes.
di ba?
That's
And the
correct.
rights and
So
obligations.
I guess let's
yeah.
go now to basically if you have properties and you're already planning, not necessarily kung matanda ka na, but this is something we can clarify to people. What does it take to plan for distributing your wealth upon death? Tsaka ano yung advantages of doing that?
Yeah.
One of the most common problems Filipinos have is dividing their inheritance from relatives or loved ones who have passed on. This is usually due to the lack of will or testamentary succession left by the deceased. A will is an act whereby a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of his estate, to take effect after his death. However, creating a will is not a common practice in the Philippines, but any lawyer in the country would recommend that everyone should at least reconsider it. When it comes to preparing a will, what are the steps and requirements needed to write one? Is the assistance or a presence of a lawyer required? What are the advantages of making a will, especially since it is not a common practice of Filipinos? Good evening. You are watching Legal Help Desk on the Solar News channel. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm attorney Karen Jimeno.
And I'm attorney Rod Nepomuceno. Tonight, we will discuss your legal rights on testate succession, what you need to know about testate succession, as well as what you need to know on how to write a will and the requirements needed to make one.
Our guests for tonight are attorney Norieva de Vega and attorney Crisanto Nicolas of the Nicolas and de Vega Law Office.
All right. Good evening, Attorney Carlo.
Hi, Rod.
Attorney Nikki.
Good
All
evening,
right.
Rod.
Good evening. Thanks
Karen.
for joining us.
Karen.
Now, this topic is a paradox in a way because a lot of people don't like talking about it. You know, they think it's a morbid thing, but at the same time, we get a lot of questions.
It's actually very simple to do a will, as we will discuss later on. There's such a thing as holographic will. Hindi mo kailangan
So
abogado.
it's not as complex
Yes.
as,
Saka
as
hindi
most people think.
magastos.
Hindi magastos, you don't even need a lawyer. You don't even need any formalities. It's just very simple.
Okay.
And kasi in our experience, it's very sad. Ang pinakamasakit talaga ng mga kaso, yung magkakapatid nag-aaway-away.
Yeah,
And that will happen if you don't do a will and you don't take care of it before you die. Nag-aaway yan. Kasi usually, pag nawala yung patriarch or yung pinakapuno ng pamilya, nawawala yung bond nila and then may, yung mga hang-ups ng bata pa na paborito to, paborito. Itong isa, it crops up. And then, yun ang grabing mag-away sa kaso, magkakapatid.
But Attorney Carlo, maybe you can differentiate kung anong effect. If you don't leave a will, paano ba hatiin yung ari-arian mo and how different is it kung meron ka naiwan na will?
Well, first, let's highlight the importance of a will nga. Like you said, it's something that's catching up. Imagine, let's put into perspective. you want to buy a car or a house? You draft a contract of sale.